Hey guys, Wyatt Claypool here. In this video, I want to give more context to and discuss the situation in the city of Richmond, British Columbia, where a BC Supreme Court Justice, Barbara Young, a Stephen Harper appointee by the way, ruled in favor of the Cowichan Indigenous Band Council, who were asserting that they had Aboriginal land title over top of areas that the federal government, provincial government, and municipal governments owned. But that also put private property rights at stake because effectively this decision says the Crown never had any right to have that land and it is Aboriginal land, which means that even fee simple title, private property, which was granted by the Crown, saying that this is zoned for fee simple title land, that is also basically in dispute. The case was not taking away private property rights, but it was obviously setting a precedent that your private property rights sit a little bit lower than Aboriginal land title. And so I want to talk a little bit about the political context around this particular decision and also talk a little bit about the video that Northern Perspectives made. I think they're great at research, but I did think they got some aspects of this case wrong. They've been saying that people are wrong and saying that this is basically stealing people's private property. That is wrong if people were saying that. I don't think any court decision would actually lead to that, but I think that they were incorrecting certain people on social media. They ended up overcorrecting and making it seem like this case does not have any implications for private property. It absolutely does. Yes, it's not about private property, but it's about crown land. And if the crown didn't have the right to have crown land title over any of it, that means that the crown did not have the ability to grant fee simple title to any of the land, which means that down the road, you could end up in a situation where you have to pay a portion of your property taxes to the Cowichan Indigenous Band. And by the way, to state it out front, this has nothing to do with the average Cowichan person. This is the band council, it's the reconciliation industry lawyers and consultants. This is not actually having to do anything with normal Indigenous people. In fact, it doesn't benefit them at all. Many are still not going to be living in very good areas. They do not have individual property rights themselves. And this is just basically giving a band council, a government, a bunch of collective rights over a general area of land. Again, and it's making a lot of lawyers and consultants rich. The political context of this is that all the people who are acting shocked over this decision were helping to engineer it from the start. That includes Premier David Eby, that includes John Rustad, as well as the former BC Liberal Party, which John Rustad came from, and was the Indigenous Affairs and Reconciliation Minister under Christy Clark. The man has signed over 400 agreements that look a lot like the agreements that many people have been criticizing from the NDP, but now he acts completely divorced from the whole situation, and like this is just a random judicial happenstance, or it's just reflective of the NDP's inaction. No, much of this is actually to do with things that John Rustad was doing a decade ago and voting for just a little over a year ago. So I'm going to break this down in a little bit more detail from the previous time I did it. But before I get into it, guys, I just want to remind you, if you are in the province of British Columbia, please sign the petition that we have out at the 1BC party, because we actually want to defend property rights. We actually want to challenge the reconciliation industry, DRIPA, UNDRIP, and the current constitution in Canada that allows things like this to happen. We can't just say that it's wrong and that we should appeal it. We need to change laws. We need to fight back against stuff like this so that we don't just merely try and push back some of the excesses. We get rid of all of it. Because right now, the situation is not good for Indigenous people or every other British Columbian. It sucks for everyone unless you're a consultant, lawyer, or you're sitting on an Indigenous band council. But anyways, let's go back to the start. So that petition link will be in the description below as well as pinned at the top of the comments. Sign it if you want to organize with a party that actually wants to take care of the situation. This all basically mainly originates, although a lot of it started before 2019, a lot of really lopsided land deals were being signed by John Rustad as the Indigenous minister back before 2019 under Christy Clark. But it really heated up in 2019 when the BC NDP were in power, when this law was passed, DRIPA, DRIPA, the Declaration of the Rights of Indigenous Peoples Act, which is basically enshrining UNDRIP, which is the United Nations Declaration of the Rights of Indigenous Peoples. DRIPA is a slightly watered down version. It's not as crazy with how it tries to define Indigenous land claims. And when I say it's not as crazy, I mean UNDRIP would basically say 100% of British Columbia is Aboriginal land title. DRIPA's like maybe 75% of it is. That's the only nuance here, and this recent ruling in Richmond shows that pretty much anything can be argued to be Aboriginal land title. But this was, if you can see here, a unanimous vote on November 28th, 2019. The Legislative Assembly of British Columbia unanimously adopted the Declaration of the Rights of Indigenous Peoples Act. Yes, so this was bipartisan nonsense between the then BC NDP, the then BC Liberals, the BC NDP, and the BC Greens. Now I want to jump ahead a little bit further, a little bit closer to today. We're just going back to April of 2024 now. Here is a publication called the Tai, a publication I would not normally read, but this is an article about the island of Haida Gwaii. I actually said St. Catherine Islands the other day. I meant to say Queen Charlotte Islands. I'm not from British Columbia, so sorry if I messed up those names. But this is an article entitled, "What's Next for the Historic Haida Agreement?" This is dated the 25th of April, 2024. And it says, BC United and Conservative parties plan tough scrutiny in the legislature. Now, that sounds like then BC United leader Kevin Falcon and BC Conservative leader John Rustad were, closely scrutinizing this agreement. This was a ridiculous thing for them to have done. But Rustad quite literally praised the decision, and then he pretended to walk it back in public. But you will notice a pattern with John Rustad. David Eby is at least honestly crap. John Rustad is dishonestly crap at his job. And so in the legislature, he will praise stuff like this, and then he'll go on social media and say, I don't quite agree with it. At the same time, he votes in favor of it because he did in fact vote for this. And it says here, and though his comments would be more critical a day later, Conservative leader John Rustad, a former BC Liberal Minister of Aboriginal Relations and Reconciliation, said in the legislature that he supports title. And this is a decision where they were giving the Queen Charlotte Islands, now named Haida Gwaii, it was still named Haida Gwaii at this time, but they were giving all the land title, 100% of the land title, to the Haida Nation. All of it was Haida Nation, which really just means it's Haida Band Council. Because let's be clear, if you're an individual Indigenous person that people on Band Council don't like, they're not gonna respect your property. There was literally a property on Haida Gwaii that was bulldozed because the people who owned it were associated with a guy who was a gang member, dealing drugs. I think he murdered somebody bad. But you don't get to bulldoze someone's house for being related to them. And that happened and was given very little criticism. But this is the quote from John Rustad at the time, quote, "This is a path that we need to do to be able to bring predictability, certainty for Indigenous and non-Indigenous alike," Rustad said, adding that economic reconciliation is key, quote, "The vision of being able to provide for your children and your grandchildren, for them to be able to have the future that you want for them, is something I think that we all share. All peoples in this province share." And then the article goes on to say, although he had some questions, Rustad said the bill was an important step and he supports it. Congratulating the Haida, he added, quote, "I look forward, quite frankly, to make sure that as this process goes forward, the interests of all people in British Columbia are taken into consideration so that true reconciliation can be achieved." And then he goes on to basically criticize it as an infringement of private property on X. But I don't know why he says one thing in the legislature and then he says the populist thing out front. Right now, you have some BC Conservative MLAs criticizing this decision. Rightfully so. The problem is it doesn't really jibe with all the other things that the Conservatives are doing. Here is something else. Here is something else that John Rustad did. This is something I didn't even know about during the election. This was reported on September 30th, 2024, during the election. And it says Rustad promises to promote economic reconciliation on Orange Shirt Day. And then there's this very concerning part of the text of this article. It says that John Rustad says the BC Conservatives are committing to returning 20% of land volume in the province to First Nations. So 20% of what the Indigenous population collectively does not already own will then be given to them. 20% is quite crazy. And again, this isn't benefiting a single individual Indigenous person because these agreements, these land transfers don't mean that you get a parcel of land as an Indigenous person. You can farm it. You can, create a logging company. You can't do anything. The band council doesn't want you to do it. You're not doing it. And they probably won't want you to do it because if you become prosperous, it's harder for the band council to go to the government and try and guilt them into giving them money if their people are actually able to go get prosperity for themselves. So we have Indigenous people being held hostage both by the government, both by their own band councils, as well as the consultants and lawyers who end up incentivizing the system to move onwards inside the reconciliation industry. But what a thing to say. He wants 20% of the land volume in the province returned to First Nations. Well, what's wrong with the Richmond decision then? It's been apparently proven in court that back in the day, this may have been a portion of their land. This may have been a village some time ago. So why shouldn't they be able to have land title in the city of Richmond over government properties and potentially private property in the future? Again, and I'm going to get to the Northern Perspectives video later, and they're great researchers, by the way. I think they almost got too nuanced in this video where they were like over-reading or they were under-reading it because they were only talking about the exact outcomes of the report or of the ruling. But what's actually wrong in John Rustad's mind that they get to have Richmond? That they get to potentially have the ability to tax people in Richmond because it is their land and you're occupying it. And it says, quote, this is Rustad, returning land to First Nations is critical for achieving economic self-sufficiency. While addressing legal uncertainty surrounding rights and title, the approach will help resolve long-standing issues related to Section 35 of the Constitution, which recognizes and affirms the existence of Indigenous and treaty rights for First Nations. Now, the government is appealing this decision, and they should appeal it in court. At the same time, I would say they should probably, the BC NDP government, although they're probably not, they should be using the notwithstanding clause and saying, we don't care, you do not get to claim Aboriginal title over literal urban suburban cities. That's insane. And you could say that, well, Section 35 was one of those parts of the Constitution that you can't notwithstanding clause through. There's nothing in the Constitution that would suggest that it's an Aboriginal right to be able to claim things like property in the city of Richmond because long time ago it technically wasn't ceded over, and because it wasn't ceded over, it could still be there. If it's unceded and it's called squatters' rights. Somebody's been using it, you weren't using it, and now we're not just going to roll back the clock and say that that person who was farming in an area that they didn't know was yours now just has to rip all the stuff out of the ground and plow it back over and turn it into just hinterland. That makes no sense. But so yeah, that's something that he said in that video or in that interview. John was in favor of giving land back. He is literally a land back politician, just like the land back activists. He thinks 1/5 of the entire province should have Aboriginal say over everything that goes on there. That's ridiculous. You will never get a major project built in a lot of areas if that was true. And the fact that John basically supports DRIPA and UNDRIP makes this almost impossible. Now, he'll say he's against DRIPA, DRIPA, the Declaration of the Rights of Indigenous Peoples Act, but then he'll say in the next breath, I support UNDRIP, which is the worst version. And then his own executive director, which I showed in my previous video, Angelo Isidoro, on a podcast with an actual lefty guy, Mo Amir, who was blown away that he said this, he said that DRIPA is effectively now a free vote in caucus because he implied that the three people who used to be part of the party, Dallas Brody, Tara Armstrong, and Jordan Keeley, that they were very rude to people by thinking that they all had to agree with them, even though they wanted people to agree with them on things the BC Conservatives had in their platform. That's apparently intolerant, and that and Angelo heavily implies that DRIPA is one of those things people should be able to disagree on because people like Peter Milobar and Alia Warbus are in favor of it. By the way, it's like day 6 or 7, and Alia Warbus has not said a single word because she's a woke person. She is a BC conservative MLA from Chilliwack Cultus Lake, and she literally made a documentary celebrating somebody getting a medical transition, a medical transgender transition. That was something she made a documentary about celebrating, which is a little odd for a conservative, basically celebrating somebody doing irreparable damage to themselves, but who am I to judge? But now let's jump over to what John says about DRIPA. Well, we're going to get rid of it, but maybe we'll still keep UNDRIP, which is literally the worst version. This is a 6-second clip from the Breaker podcast to make my point here.
We are going to repeal DRIPA, but we will keep using UNDRIP as we move forward with economic reconciliation.
We're going to keep UNDRIP? DRIPA is UNDRIP effectively. I don't know what he's even talking about here. But again, now he's trying to celebrate, oh, look, we got the NDP to appeal the decision. They were going to appeal the decision anyways. And this is weak need. The BC government should be passing a piece of legislation. They should be using the notwithstanding clause in order to say that every single municipality, city, suburban area cannot have Aboriginal title placed over it. If there is private property on that area, it cannot cover Aboriginal land title. Even if you want to have a certain area that's close to a reserve be Aboriginal land title, which maybe we can argue about, I'd rather Indigenous people just be given private property rights like the rest of us and be able to prosper without having to walk completely away from the territory that they live in. For an Indigenous person to own private property, they basically have to leave their entire community and go live somewhere else in order to find it. They can't have private property on their own territory, which is sad. They should be able to have private property within their own lands. It's like we want to respect the Indigenous people's connection to their lands, but you better not try and open your own small business on the territory, or if people on the band council don't like you, they'll just bulldoze your building. But again, it was whispers, nothing from John when this happened on Haida Gwaii. He celebrated it, and then he criticized the decision after he celebrated it. But, that's neither here nor there. And then he kicked Dallas Brody out of the BC Conservatives for calling out the Kamloops Indigenous or the Kamloops residential school grave hoax, which, by the way, is very relevant to all this. How do you think people get lopsided agreements signed to them? Well, you're not going to sign it. It's like you are basically besmirching the memories of those children who were buried there, even though there's no dead children under that residential school. But the whole point is that the hoax allows you to basically enter a meeting with the upper hand. Really, you're not going to sign an agreement the year after the Kamloops residential school thing happened? And Dallas Brody defending lawyers for saying that they shouldn't have to be forced to repeat that untruth in order to get certified by the BC Law Society bar, that was somehow racist or whatever. That was somehow intolerant. And Rustad kicked her out after she went on Francis Widdowson's podcast and made fun of postmodernists for basically saying that you should have to basically just accept anything told to you because it's somebody else's truth, in which many of these people are just making things up. Their grandmother didn't tell them this. Nobody told them this. They just made it up. And that's pretty much it. Some people believe it in good faith, but the people who discovered it originally are the people who should know better and have the evidence at hand to tell them that this did not happen. But so now, after I've talked about all that, again, sign the 1BC petition. We actually want to do everything we can to stop things like this happening, not just saying, can we appeal? Can we get an appeal? Can we figure this out in like 3 years, and when we lose, we'll just go silent again? We actually want to change as much as we can to prevent this stuff. So sign that petition, description below, top of the comments. Now I want to move over to the thing that Northern Perspectives had said. And again, they do great videos. I love Northern Perspectives content. I thought in their video, they were a little bit overwrought in claiming that this doesn't have anything to do with private property. I know there were some cranks on social media saying this is going to have an Indigenous person steal your house from you. It's like, no, that's not what it's saying at all. The whole point, though, is it's saying that the title must be respected. And so if they ever challenge private property rights, the precedent is that you would lose effectively. That's what the judge said. So they were mostly only reading the executive summary, and people who went a little bit deeper were finding the quotes from the judge, acknowledging that, yes, the case only had to do with Crown land, municipal and provincial lands, but that because the Crown granted those private property, rights, the fee simple title land, because they were the ones who created it, well, technically that was illegitimate. So Aboriginal title, in theory, if they challenged that private property, would overrule the fee simple title. So here we have this quote that Jamie Sarkonik has highlighted. This is from the judge, and it says, however, the Cowichan have not challenged the validity of the private fee simple interests, and those interests are valid until such a time as a court may determine otherwise, or until conflicting interests are otherwise resolved through negotiations. And so it says, while I agree with BC that the private landowners' fee simple interests are valid and remain so for the time being, I do not agree that the recognition of the Cowichan's Aboriginal titles is appropriately defined with reference to those interests. So basically, it's just that the judge is saying that right now we don't really know if private property rights, we have not ruled on it, so we're in stasis right now. We will continue with the idea that your private property rights mean something until such a time that we have another case where we rule otherwise. And then Jamie Sarkonik here, we read this on the other video, but this is basically saying that I don't think Northern Perspectives may have seen this stuff, or maybe they just kind of ignored it. I don't know. But Jamie Sarkonik said, notably, the Cowichan didn't ask the courts to extinguish private title, only government title. They held back a bit. We haven't seen the full power of the Aboriginal title. The judge implies here that private property is on the chopping block next, because this is one of the judge's points. It says, finally, BC submits that the plaintiff's contention that a declaration of invalidity would not impact private interests is of little comfort. The only comfort of the plaintiffs offer non-party landowners is their assertion in this proceeding that they do not seek to invalidate those fee simple titles. The basis on which they seek a declaration of invalidity against Richmond and Canada v. FPA could be turned against the private landowners next. And then it goes on to say, and then Jamie says, in this spectacular roller coaster of a paragraph, the judge scolds Richmond's lawyers for bringing up a big picture concerns about what his will do to the economy, what this will do to the economy and the integrity of the property system. And then she agrees with them on yellow. I just want to jump down to the yellow part, because this is the part that is very telling. It says, a precedent that will follow from this case is that the provincial crown grants of fee simple interest do not extinguish nor permanently displace Aboriginal title. Yeah, so that's a bit of a problem. And I remember there's another quote. It's not here, but they say that we don't have to determine how much Aboriginal title exists in the context that private property rights are already there. We have to determine how much private property rights still exist now that we've recognized Aboriginal title, if that case is brought. So yes, this does affect private property. No one's home is being stolen from them, like some people may have said, but it's also not a case where it has nothing to do with private property. Does the literal case have nothing to do with it? Does what the judge was directly ruling on have nothing to do with it? Yes, but the implications of the case, the precedent, and the judge's comments have to do with fee simple interest being undermined. So I will probably just leave it there. Again, Northern Perspectives does great research, and they are correct in debunking people who are claiming things like, this is your land being stolen from you, you're going to have your property like confiscated. No, but you could imagine a world where the Cowichan Indigenous Band could argue that while, yes, you have your private property already there and they have no interest in taking it from you, because probably a court wouldn't let them go that far, they could say, well, because we own the land, in effect, it's our land title, the city or you directly must pay us a certain portion of property taxes because it's our property. That's where you could see this going. Yeah, are you going to have your home confiscated? No, but maybe they can block certain things from being built without oversight from them, without extra sign-off. Maybe they could tax you more. There could be a lot of things that could come out of this. In fact, the whole case is on an 18-month pause before the ruling actually takes effect, while the two sides negotiate how they're actually going to resolve Aboriginal title being placed over the city and what the city's going to do to like honor it in some way. But anyways, so that should be it for me today, guys. Make sure to like the video, subscribe to the channel, leave a comment, do all that great stuff, and sign up on the 1BC petition if you live in the province of British Columbia. I'll see you guys all later.